Good afternoon, everyone. I am Elizabeth Owens, Director of Risk Control and Consulting at HAI Group. Thank you for joining us today for this important topic of the Violence Against Women Act, or VAWA. This act was recently reauthorized in 2022, and housing provisions were included for those that are survivors of VAWA violence and/or abuse. For this presentation, we are thrilled to have Dr. Dhill, a principal consultant at Advocates for Human Potential. She has administered multiple government programs over the past 30 years, including serving as a continuum of care lead in Southern California and overseeing housing and homeless programs for local governments. She speaks at national and international conferences on some of society's most pressing issues around housing and homelessness for special populations, including youth, veterans, seniors, justice involved, and survivors of violence. She has provided training to thousands of individuals over the years and is very passionate about training on the Violence Against Women Act. And with that introduction, I'd like to hand it over to Dr. Dhill. Dr. Dhill, thank you so much for your time today. We really appreciate you being here with us.
Thank you so much, Elizabeth. And yes, I am so excited to be here with you all. And first, I'd love to give a big thank you to the HAI team for this opportunity to partner. The HAI group found this topic of utmost importance to their company due to the amount of people that it can impact. And they also value the opportunity to provide training to you all to strengthen your operations. So a big thank you again to the HAI group for your partnership and investment into our communities. And this topic is of major importance to me. Number one, because A, we can save a life. I guess it's number one and A. And number two, it's just the right thing to do to protect people who may suffer from violence. So as mentioned, my name is Deme Dhill, and I'm a principal consultant at Advocates for Human Potential, overseeing housing and homelessness initiatives. We administer billions of government funding nationally in 37 states, and I get a chance to train and provide technical assistance on this topic all over the country. And again, working with special populations and regarding federal laws, such as anti-discrimination, addressing racial disparities, fair housing, equal access, and a host of other topics. As a matter of fact, I'll be doing another training this afternoon on capital projects, so a little bit different on the real estate side. But the bottom line is we have a host of real life solutions to help solve complex community issues. And so moving on to VAWA, and we'll get started. So VAWA was authorized in 1994, 30 years ago when I started in this work. And it's gone through many iterations to get where we're at now. And the 2022 reauthorization expands protections for survivors. So this training course is considered the next level of training for VAWA because it's not about the history and how we got here, but more specifically about the latest reauthorization that is very prescribed by federal law. So you get a disclaimer from me from the very beginning. This training is jam-packed with written content, more than I usually like to see on a slide. It is also very black and white. And so there's less gray area as this is the federal regulations, and we are training you to be prepared and to respond to reduce liability for agencies. But at the end of the day, this is all about you, training you to be a better employee and for the workforce. And so I also would like to mention at the beginning here that this training can be triggering because we are talking about violence. And violence can be tricky. It can evoke some feelings, whether you have been personally impacted or experienced vicarious trauma in the work that you do or from family or friends. And I know for me personally, it can trigger some childhood trauma. So please be aware and protect your mental health as needed. We also know as practitioners that situations that may fall under VAWA can be complicated, and it's not always cut and dry. And some things have to be handled on a case-by-case basis. And so I'll do my best at the end to answer your questions at the end of the presentation, and you guys will have my email. So if you need to reach me as needed. And so with that being said, we're just going to jump right in and get started. So to begin, HUD has now invested more into ensuring that survivors have what they need to prevent further victimization. And HUD has also developed an enforcement arm to ensure that federally assisted housing programs comply with the new regulations. And so today, the goal is really to describe the changes to VAWA that were enacted in 2022. And hopefully you'll be able to name at least 3 populations protected under VAWA. And we'll discuss some complexities of providing housing to survivors of domestic violence and intimate partner violence. And then we'll also talk about some penalties that can be incurred if organizations do not enact the new VAWA policies and procedures. So under VAWA, this covers applicants and tenants of housing assistance programs. Survivors must be able to access certain remedies, such as the availability to request an emergency transfer for safety reasons. And VAWA established changes that significantly impact our HUD housing programs that must comply. Enforcement has already begun. HUD has been enforcing cases over the last several months and has settlement agreements in place with housing entities. And swift changes have to be made to current housing policies and procedures to ensure that domestic violence survivors are aware of and offered protections under federal law. So who are we talking about? We're talking about people who have previously or currently experiencing domestic, sexual, intimate partner violence, sexual assault, human trafficking, dating violence, or stalking. And the types of abuse can include physical, sexual, emotional, economic, psychological, and technological. And we will go into these terms in just a few minutes so that you have a clear understanding of what they mean. We're going to start with intimate partner violence and kind of understanding it. So sometimes domestic violence is called intimate partner violence. It can include physical, sexual, or emotional abuse or sexual coercion and stalking by a current or former intimate partner. It can affect anyone, but it often affects women in the United States. And this power and control is used as a pattern of behavior from the perpetrator. And it's more than just physical abuse. It's often a series of behaviors which can come together to reinforce one another. And together they can build barriers for a person to escape the violence, such as economic abuse, folks being afraid to leave because they cannot provide for themselves, or they could be living in a housing situation where the primary breadwinner is the abuser, but not paying rent, as you'll see in some cases as we talk later on in the presentation. There's isolation, which sometimes folks can be isolated from family, friends, and support systems that would help them. And then there's threats that can reinforce fear, and sexual abuse is also common. It can happen to anyone. It involves an imbalance of power and control, and abusers can use intimidating and hurtful words and behaviors. And it often takes place within a cycle, and a cycle does not have a time limit. Sometimes the cycle can be quick, it happens over a few days, and sometimes it can be over a series of years where there's tension building phase. The abuse happens, and then there's this honeymoon phase where you apologize, get back together, and stay together. And that's often the case with domestic violence situations. Millions of people are impacted by this. The CDC and the national regarding the National Intimate Partner and Sexual Violence Survey shows that 41% of women and 26% of men have experienced sexual or physical violence and or stalking sometimes during their lives. 75% of female survivors and 48% of male survivors can experience a related injury, and then 1 out of 5 become homicide victims that can be murdered or killed by their partner. It's the leading cause of homelessness among women. Women say that domestic violence was the immediate cause, and 38% became homeless due to domestic violence at some point in their lives, and 85% of survivors entering a shelter identified safety as their first need. Okay, so here we go. HUD has invested more into ensuring that survivors have what they need to prevent further victimization, and as well as developed an enforcement arm to ensure that we comply with the law. So today we're going to talk about the new terms. The reauthorization does not replace the former VAWA legislation. So that's very important that you know and understand that this is not a replacement of what was already existing, but it rather amends and adds more protections with all the former protections in place. So it expands the law. And there are some key changes and clarifications, which include a plethora of items, such as new terms as the description of who we're talking about, who's covered. There's also a change to the categorical definition of homelessness, which we don't have time to cover today, but it is worth an honorable mention. We're not here today to talk about homelessness, but the categorical definition of homelessness has been changed, category 4. And today we will also cover the baseline of laws around VAWA compliance and the new VAWA forms. So VAWA applies to all of these federally assisted programs. And so I know we've got folks here from all over the country, and you are probably working underneath one of these HUD assisted funded programs. And so at this point, I have not found a HUD housing program that VAWA does not comply with. So basically all federally HUD assisted housing programs need to comply with the law. And so now we're going to get into the terms. So domestic violence includes felony or misdemeanor crimes committed by a current or former spouse or an intimate partner of the victim under the family domestic violence laws within that jurisdiction receiving grant funding, and in the case of victim services. So it includes the use or attempted use of physical abuse, sexual abuse, or any pattern of coercive behavior committed, enabled, solicited to gain or maintain power and control over a victim or survivor, including verbal, physiological, economic, technological abuse that may or may not constitute criminal behavior. So that's key. It may or may not constitute criminal behavior. And this is typically done by a former spouse or an intimate partner, or a person situated similarly to the spouse or victim, is cohabitating or has cohabitated with the person. They may share a child in common, and they commit acts against a youth or adult victim who is protected from those acts under the family or domestic violence laws. I also want to mention that victims of human trafficking are also covered by VAWA. I like to put that plug in for human trafficking, as this is an issue in many communities. And it also includes youth who are commercially sexually exploited children or minors. Dating violence, another term. So this is regarding someone who's been in some sort of social or romantic relationship of an intimate nature with the survivor or victim, and where the existence of such relationship shall be determined by the length of the relationship, the type of relationship, and the frequency of interaction between the person involved. So in this case, if someone tells you they are experiencing data violence, I would say just believe them. I wouldn't worry so much about the length of the relationship, the type of relationship. If they say it, they mean it, and we want to trust that that is true. Sexual assault is any non-consensual sexual act proscribed by federal law, tribal law, or state law, including when the victim lacks capacity to consent. And stalking means engaging in a course of conduct directed at a specific person that will cause a reasonable person to fear for their safety or the safety of others, and they can suffer severe emotional distress. Human trafficking and survivors of trafficking is newly called out by HUD. They actually just completed a study around the housing needs of survivors in human trafficking, and they have found that there's more and more evidence that links homelessness, human trafficking victims to domestic violence. So these are people who are victims of crime that involve the exploitation of a person for labor, services, or commercial sex. Economic abuse is a newer term. And in this context, this is around domestic violence, dating violence, and abuse later in life. And so this is behavior that is coercive or deceptive, and it uses somebody's funding or money to acquire, use, maintain economic resources, including coercion, fraud, and manipulation to restrict access to money, assets, credit, or even financial information. And it's unfairly using a person's economic resources for one's own advantage. And it exerts undue influence over a person's financial and economic behavior or decisions, including forcing a default on joint or other financial obligations, exploiting a power of attorney or guardianship or conservatorship, or failing and neglecting to act in the best interest of a person to one whom has fiduciary duty. Technological abuse. So this is a pattern or behavior that can occur with domestic violence where someone is stalking or intending to harm or threaten, intimidate, control, and harass or impersonate, exploit, extort, or monitor, except otherwise permitted by law, another person using any form of technology. So this is all of your technological devices, such as social media, online spaces, platforms, computers, mobile devices, cameras, imaging programs, app, artificial intelligence, location tracking, and other communication technologies and other emerging technologies. So HUD was clear with this when they said, we're going to expand it to include any emerging technology, because as we know, technology is always changing day by day and growing. Pop quiz. Okay, we're going to see, are you paying attention this morning? Because it is a lot, right? We're talking about a lot of stuff. So you can drop in the chat, name a housing program covered by the Violence Against Women Act. Let's see if folks are listening. What HUD housing programs are covered under VAWA? Oh, I can see the chat going off. Awesome. Okay, you guys are listening, so you got to point at yourself. My housing program, if it's federally assisted, is covered under VAWA. Awesome. Okay, now let's name 2 types of abuse covered under VAWA. We just went under the terms. Can you remember 2 of them? 2 types of abuse covered under the Violence Against Women Act. Thumb? Awesome. Even though this is a dry presentation, you guys are getting it in. Thank you so much for listening. I know it's very black and white, and you will receive a copy of the presentation. We will make sure that you get the presentation with all citations of all data points so that you guys are able to get to information yourself. That way, if you're like me and like, I'm a researcher, my degree is in research, so I like to nerd out on stuff. So if you want to nerd out on the presentation, you are more than welcome to. You will have this information. We will send it out to you for everyone who registered. Okay, moving on. You guys are paying attention. Thank you so much. I appreciate that. All right. So who's covered? Housing protections in part are available to the folks that we've already talked about experiencing domestic violence. And the survivor does not have to be married to that person. It doesn't matter if they live with them or not. They don't have to live with them to be protected. It doesn't matter how long ago they experienced the violence. And their immigration status in of itself does not impact a survivor's rights to VAWA protections. And the housing protections in part apply to a survivor if they're applying for or living in a shelter, a transitional housing program, a permanent housing program, permanent supportive housing program that is subsidized by the federal government, or a federal affordable housing program. And this is very important. VAWA protects survivors regardless of their sex, gender identity, or sexual orientation, and regardless of the sex, gender identity, or sexual orientation of the person that caused harm. So it does not matter if it's female with male, male with female, female on female, male on male. It does not matter. And this includes any gender and gender nonconforming. And so under VAWA, someone who's experienced domestic violence and dating violence and sexual assault or stalking cannot be denied admission or assistance under a HUD-funded program, or access, right, to a HUD-funded program because of the violence committed against them. They can't be evicted from a HUD-subsidized program, nor have their assistance terminated because violence was committed against them. They cannot be denied assistance of admissions, evicted, or have their assistance terminated for reasons related to VAWA, such as having an eviction record or a criminal history or a bad credit history. Where I've seen a criminal history show up, sometimes it shows up where somebody may have something on their criminal record that doesn't look too good, such as with youth and human trafficking. I would see prostitution cases or drugs. And that was part of the life that they lived while they were in those human trafficking situations. So while that is a criminal history, it was related to VAWA. And so they must also have the option to stay in their housing, even if there's been criminal activity directly related to the abuse. And they can request an emergency transfer from the housing provider for their own safety regarding the violence that has been committed against them. They must be allowed to move with continued assistance if the survivor has a Section 8 voucher or housing choice voucher, as well as permanent supportive housing under the continuum of care. They must be able to provide proof to the housing provider by self-certifying. So that means you must take their word. And they can use a self-certification form, HUD 5382, which, and they don't need to provide more proof. If they say this is happening, you need to believe them and act as so. They must receive HUD's notification of VAWA housing rights from the housing provider and a copy of the self-certification form when they are denied admission to a HUD subsidized housing program or unit, when they are admitted during the admission process to a HUD subsidized unit or a HUD program, and when they give notice of an eviction from a HUD subsidized unit or notice of termination from a program. So you have to give them their housing rights every time these actions are taken. They have a right to strict confidentiality of the information regarding their status as a survivor. So that means you cannot just talk to anybody who calls and wants to know more. You can't talk to the neighbors. You can't talk to other people that are not specifically involved in the case. And that if they've given you a right to talk to them in writing, then you have that ability, but you should not break confidentiality regarding their status as a survivor. They can also request a lease bifurcation from the owner and the landlord to remove a perpetrator from the lease or the unit. And if the housing provider bifurcates, it must be done consistent with the applicable federal, state, or local laws and the requirements of the HUD housing program. They cannot be coerced, intimidated, threatened, or retaliated against by a HUD subsidized housing provider for seeking or exercising VAWA protections. And they have the right to seek law enforcement without, any backlash for emergency assistance for themselves or others without being penalized by local laws, policies for these requests, or because they were a victim of criminal activity. HUD also has moved to remove barriers for persons with criminal records relating to domestic violence. This just came out March 2024. So it's literally just a couple of months old that HUD said that they are going to take a closer look at best practices to ensure that folks are not automatically denied housing based on the presence of a criminal conviction other than where explicitly prohibited by federal law. You can disregard criminal history that is unlikely to bear a fitness on tenancy, such as arrest records, like we talked about earlier with the young person who was human trafficked that also had prostitution cases, sealed or expunged records, older convictions, and convictions not involving violence or harm to a person or property. Using individualized assessments to determine whether an applicant truly poses a risk to the persons or property, and taking into account other factors such as employment or engagement in alcohol or drug treatment or constructive community involvement. Providing applicants with criminal history records with reasonable time and an opportunity to provide supporting information regarding mitigating factors before an admission decision is made. So you're not supposed to just completely say, you didn't meet our requirements, you're not getting in. You're supposed to take a closer look and ensure that folks who have experienced violence have a chance to basically share their story and have mitigating factors regarding their case to increase access to federally assisted housing for domestic violence survivors. HUD has a new compliance review process. So this requires HUD and other covered agencies to establish a compliance review process and incorporate this process into existing compliance review processes where possible. And HUD enumerates 6 items for the compliance review, which requires HUD to conduct a review on a regular basis and to publicly disclose its assessment of the information collected during the compliance review process. So all appropriate stakeholders, which means it is I, have to implement these changes now as of March. And these regulations must define standards of compliance under HUD's covered housing programs, including detailed reporting. So if somebody tells you that they are experiencing violence or that they are covered under VAWA and that you suspect would be covered under VAWA, you need to make sure that you document. You also must have reporting on emergency transfers as well as corrective action plans and standards where compliance standards have not been met. The 6 items that HUD's looking at is compliance with the requirements regarding any denial of assistance, tenancy, or occupancy rights based on domestic violence, compliance with confidentiality that we talked about before, compliance with the notifications that they're receiving their rights at those intervals, and also the provisions of accepting documentation, such as the self-certification, compliance with any emergency transfer request, or if you know a person needs to be transferred because they're experiencing domestic violence, you need to comply, and compliance with retaliation. So we shall not be retaliating against victims of violence. So now VAWA has an enforcement arm. So this is the part of VAWA that I really like. And when I say like, I don't want to say the enforcement part is what I like, but I like the fact that they actually have people who are working to ensure that VAWA is followed, right? It used to just kind of live there and it was like, who's responsible? Is it the SNAP's office? What office is responsible for VAWA? So now it falls under Fair Housing and Equal Opportunity. So FHEO reviews the complaints. So they have a team of lawyers there now who are physically responsible for these cases, and they decide what happens in those steps. So they accept complaints, they investigate them, and they enforce VAWA using the Fair Housing Act complaint process. So that's new. So VAWA now falls under Fair Housing. And so this is also current fair housing regulations and consolidated HUD hearing procedures. So it falls under fair housing, but also the procedures for civil rights matters. VAWA complainants do not need to allege a violation of the Fair Housing Act to be accepted or investigated, and a complainant may not file a case longer than 1 year. So they have a year to file a violation. So what's keeping you awake at night? This is where we pause and we say, okay, what are we doing, right? What's happening within our organization? What are the difficulties we're experiencing? Is this an issue for us? What types of cases are we seeing? Are we really looking at what's happening? And so we're just going to pause for a second. And I want you to think about within your organization, what are your current practices for households impacted by VAWA? And what are some of the difficulties you're encountering in serving VAWA households, and also any successful strategies you may have used? So I'm gonna give you guys a chance to respond to this. The first bullet point, I just want you to think about, do our current practices align with what we've learned today? Within our organization, do our current practices align with the new VAWA reauthorization? Are all our staff trained up and prepared to deal with VAWA cases? Do we have a person who's a specialist within our organization that would take on VAWA cases and really truly knows and understands the law? So I want you to think about those current practices and decide just within your own mind, are they adequate? Or is it something we need to extend and expand for our policies and procedures? Okay. And then secondly, I want you to think about what difficulties have you encountered in serving a VAWA household. So with that being said, I'm just going to pause for a second, and I want to see if somebody either wants to come off mute or post something in the chat about the difficulties they have in serving VAWA households.
Dr. Hill, we have a couple hands up.
Okay, if you want to.
Sure, I'll have Kelly Fuller, if you just raised your hand when Dr. Hill mentioned that, so I'm going to unmute you. Go ahead, Kelly.
Can you hear me?
Yes.
Yes.
Hi. So I think our agency, we've quite a few policies and procedures in place. Obviously, there's some room for improvement, but for the most part, we definitely have a focus on VAWA. But one of the concerns I have is I'm a little unclear about how bifurcation works. And I guess I understand that from a lease perspective, which is handled by the landlord, that they have, freedom to do what they need to do. But I'm a little unclear about what happens with the voucher. I work for our voucher program here, so I don't understand how the voucher gets bifurcated.
Okay, that makes a lot of sense. So with a bifurcation of a lease, and I'm not gonna go down a rabbit hole, but I'm just gonna mention the first step that you would do is remove the abuser. So it is an administrative process within your organization, so that if you know that you have an abuser that is in the household and part of that household, the goal would be to remove that abuser from the immediate household. That would be done as an administrative procedure within your organization, your federally assisted housing program, and in partnership with the landlord. Okay, so it's kind of twofold. And so if you want to reach out to me afterwards, and I can kind of walk you through what that could look like. But at the end of the day, this involves two-step processes, right? It's your internal process with your organization, as well as working with the landlord to remove that person from tenancy.
But does the voucher now go to the other remaining member if the abuser is the head of household?
Correct.
Automatically?
The voucher stays with the person who is the head of household, that would be the person being abused. Yes.
No, if the head of household is the abuser.
If the head of household is the abuser, this is where we get into, okay, this is a case by case basis, right?
Okay.
We're going to have to determine what happens with that household. So I think this is one that you should reach out to me afterwards, and we can talk about how you would deal with that situation. Because if the head of household is the abuser, now you have a different type of problem.
Right.
And we need to make sure that we follow the law to protect the household, the folks that are left remaining. And you may need to change the head of household. That is something that can happen. But let's have an offline conversation about that, because I know there could be some eligibility requirements around that. And so it isn't something that is kind of clear, cut and dry. This is one of those, okay, we need to consider all the facts, right, of the case, and then we make steps and determinations based on the federal law and what should happen next.
Understood. Fair enough. Thank you.
Okay, you're welcome. Is there somebody else that wanted to come off of mute around concerns and challenges they're seeing under difficulty in serving VAWA households?
We have several other hands up. Jennifer Todd Warfield, I'm going to allow you to talk if you want to come off mute.
Hello, everyone. One of the difficulties that my agency encounters as it relates to VAWA, I work in the LIPH, low income public housing, for our agency, and we have residents who, not all, but some, who file a VAWA, and we honor their VAWA request. And the way our procedure is set up, we quickly identify a unit available, and a lot of times the unit that is offered that would allow for the immediate transfer of the resident to another development of ours, that would, so to speak, put them out of harm's way, is declined because the resident does not like the location. And we still have an obligation, at least at our agency, we still have an obligation to actually move that resident.
Yes, I have seen this happen multiple occasions where somebody does not want to move. And do the clients have choice?
For LIPH, no.
But does a client have a choice if they want to move? This is what I'm saying. Do they have a choice if they want to move or not? So the answer is yes.
I mean, well, yes, they do have a choice on whether or not they want to move, but if they choose to well, let me preface, we also have scattered site housing,
Mhm.
and it's more desirable housing. However, when we don't have availability and we're trying to address the immediate emergent need, it causes an issue. And
Yes.
we've had VAWA with people who have applied for VAWA who have actually been on the list longer than anticipated because of the fact that they're waiting for a more preferable place to move.
Yes, and I've seen this happen because clients do have choice. They can say, you know what, I don't want to move to that neighborhood. I don't want to uproot my kids. I don't want to, intervene with their schooling, things like that. So this happens, right? And our clients do have choice. So in this case, if I were that housing program, the first thing I would be doing is documenting, right? I want to document every step that happens. I want to document that this person declined. I may even have them sign something stating they declined. That way, we can do our best to ensure that we're covering all of our bases, that we did offer them emergency housing. I may even want to work with a domestic violence provider to talk about a risk assessment, right? Is this person in immediate danger? Do we need to be worried about them today? And working with that organization that really has the skill set to work with that, VAWA survivor, right? They're used to dealing with folks that experience domestic violence, and they may be able to get through a little better than a houser would, right? Because I'm a houser, right? I house people for a living, but this is a complicated subject, and clients do have rights and they have choice. So the main thing I would do would be to protect the liability of my organization and document what we offered. But then I would also be thinking about when something else comes along, can I get that person that scattered site voucher? Or is there another opportunity for me to move them to another development? So while you're documenting and you're taking all the steps necessary to support that VAWA household, you also want to see what you can potentially do in the future to continue to support them. And again, it's complicated, right? The law says one thing, but we're talking about people's lives. And it can get very emotional, right? Because we're talking about families and individuals that make choices, and sometimes those choices may not always be in their own best interest, but they have the power to make that choice and say yes or no. And then our job is to ensure that we cover all of our bases when it comes down to liability. And so I've taken a couple questions and I will take some more at the end. We've got to keep moving on in the presentation. If folks want to drop any successful strategies they have used in the chat, I would love to hear about things that have actually worked. I've gone to a few conferences and trainings, and I've got a chance to hear from organizations about things that they're doing that have worked for them to increase their protections for domestic violence survivors. And so if you have any strategies around something that your organization has done recently or over the last couple of years to really increase protections for survivors, please do share that information in the chat, because iron sharpens iron, right? We want to make sure that we're talking about what are the best practices? How can we help other organizations strengthen their own operations? I've seen things such as a threat assessment, right? That I just mentioned in this last case that she had where a family chose not to move because I don't want to move. I don't want to go over there. I'd rather have that scattered site voucher. I've seen where organizations work closely hand in hand with domestic violence organizations to get the services that that person needs. I've seen a lot of different things in the field that have been helpful. So if you have any things that you would like to share, please share those things in the chat. And
Dr.
we're
Hill,
going to move on.
we just
Go
had
ahead.
one quick situation that's been brought up by several people that I just wanted to address quickly. They're talking about
Okay.
attackers who are tenants are moving, and then they invite the person back into the household or move them back in and not tell anyone. Is that something that you run into, you see often in these situations?
Yes, that's part of that cycle of domestic violence that we talked about at the beginning, right? We have this huge blowout, something happens, somebody's been abused in some way, shape, or form, and then the perpetrator somehow works their way back in, right? I'm sorry, please forgive me. You know, I'm going to show you everything. I'm going to love bomb you. I'm going to show you everything. I'm going to be that person that you expected me to be. And somehow they end up back together with that person. Yes, this happens all the time. Not just in housing projects, right? This happens in real life situations where people separate and come back together. I think this is another example of document, right? If you have bifurcated this person from the lease, they need to be gone. They should not be living in that household. So that's the number one piece. And that person's house unit voucher can be jeopardized if they've allowed a perpetrator to return. Sometimes they're even violating restraining orders. I've seen that as the case because, oh, I've forgiven you and now I'm going to let you come back because of the children or whatever it is. I think this is, again, where you have to document. Also, you have to work with organizations that can help that household and that family to really think about, okay, well, how does this person still parent, right? So maybe they have children. How does this person still parent, but not necessarily come to my house, right? So how do you also follow kind of the boundaries that have been set and the protections that have been set to help that person? And again, case by case basis, it is very complicated. This is the part where, as an entity, you want to protect yourself from liability. You want to continue to document everything that you can around this case and to support that family. Number one, to prevent eviction, to prevent terminations, and to prevent further violence. So again, it's complicated. There is no one size fits all. We're going to solve this in a day. These are lives we're talking about. So you just have to do everything that you can within your power, within your organization, to ensure that you're doing the steps necessary to protect your organization from liability, as well as to give that family, that person, the support they need to protect themselves. Okay, sorry, I'm gonna move on. And I know that's a complicated answer for a complicated question. But again, even though the law is black and white, there's so many gray areas. And would love to see some strategies you use. And if you could share those in the chat, I think that'll be helpful. And then we'll have a little more time at the end to do some more Q&A. Moving on. Okay, so to implement new provisions, do you have the ability to identify new and existing households that would meet the criteria? So you may already have some folks, maybe there's an incident that took place, you kind of got wind of it. You didn't really think too far into it because it didn't go anywhere. No police report has been filed, but maybe there was some disturbance that happened at one of your properties, right? And you know something is happening, but you can't really put your finger on it. This would create an opportunity to identify a new VAWA household or an existing household that could potentially meet the criteria. And then the provisions for confidentiality in all matters pertaining to VAWA households. You need to ensure that these are the activities that your PHA is doing. So identifying the households, making sure they know and understand their rights, making sure there's non-coercion practices, providing practical assistance, and law enforcement involvement as needed. Although that's something that I feel is very complicated when law enforcement gets involved. Sometimes you might have to have law enforcement involved, depending on the nature and seriousness and the health and safety of those folks that are experiencing the violence. You need to make sure that you have policies and procedures reflecting the new provisions. And then you want to have all related staff training. So you're here today, you're getting training. This is awesome. I'm so glad you're here. I think also a great training that would be helpful too is training around human trafficking, just because it is covered under VAWA. And I think that's something that's not as explored. And especially when we're talking about our younger populations up to age 24. And then you want to track all the implementation that you've done. So you want to track the fact that you've trained all your staff today, right? Or that you went to training yourself. You want to track that you have increased your policies and procedures to comply with the law. You want to track any cases and make sure that you have the appropriate documentation so that if something did happen, you have been reporting that information, you have that in that person's file, and that you have continued on documenting. These are practical steps that your organization can take to help reduce risks and liability. New applicants that are applying to become an applicant of your housing program, must be offered the opportunity to self-identify as a VAWA household. They must be offered the opportunity to self-identify at any point in their occupancy. And when VAWA protections are requested, housing providers should provide the protection based solely on that request. So take them at face value. If they say that they are experiencing some sort of violence, believe them. Okay, so take that at face value. And you can also ask them to provide one supporting documentation, whether it's a police report, a restraining order, a law enforcement, incident, but also self-certification. If they cannot come up with this information, you need to give them the HUD form. I think it's 5380, and allow them to sign it so that you can have that as far as documentation. And that is the only documentation that you should need to prove that they are a VAWA household. Remember that households experiencing domestic violence may not be able to safely report these crimes. These experiences are often seen as private matters. Abusers exercise control and power, and as we've seen, and disclosure may be actively dangerous. So people may be fearful. They may be fearful of talking. They may be fearful of sharing information. There may be an incident that happened on site and they don't want to talk about it. They close the door and say, no, I'm fine. Thank you. And it could be because they fear for their own safety. So creating a safe space includes making reporting easy and discreet. Sometimes it's a link on your website. It could be you posting VAWA posters in public facing places, like in the laundry room of a project-based site, places that are controlled by your housing authority or your housing program, and ensuring that all your staff are trained is essential. So cooperating with domestic violence experts in your community is also vital to success. So you want to work with educated local partners who can offer multiple benefits. So these are things that your PHA doesn't normally do. It's kind of out of the scope of what you do. You house people, you get them housed, and you try to keep them housed. That's your job, right? We want to get folks in housing. We want 100% tenancy. We want to keep them housed. We want to, ensure that our properties run smoothly. Partners can help review your current and proposed practices for safety, sensitivity, and practicality. And when we talk about practicality, you're talking about those real life cases you guys have been mentioning, right? While the law says one thing, when we, try to apply this, it doesn't quite fit. It's like a round peg in a square hole, or how's that go? A square hole, a round hole. You guys know exactly what I mean. At the end of the day, the partners may provide trainings on topics such as trauma-informed care, the way that you interview folks, and active listening. Partners may also be able to educate staff about how to spot patterns that may indicate VAWA violence. I know one for me as a landlord is the constant fighting. If I get reports from neighbors that there's arguing going on, things being thrown in the house, physical violence happening next door, we can hear it, we know it's happening. Those are usually indicators that there's something happening there when you're starting to get complaints from neighbors. And so those are ways to spot patterns. Again, confidentiality procedures apply to all households. I have one neighbor reporting that there's a fight that happened in the unit. Am I going to go next door to all the other neighbors and say, has unit 1 been fighting? No, right? Because you could be violating their confidentiality. So this includes sharing information with only written consent as a general practice, and carefully guarding all personally identifying information of any person served, not just VAWA households. In addition, VAWA household information must be maintained in the strictest of confidence. Do not enter them into a shared database, and please don't disclose to anyone without explicit, time-limited written consent. So that should be part of your policies, that information should only be disclosed with written permission. They should not be in some sort of database, such as the Homeless Management Information System. And information should not be disclosed to anyone without explicit, time-limited, and written consent. And it cannot be a requirement to receive services. We've got to enter your data into the system so that we can get you connected to XYZ. No, they can be entered into systems in a different way, often as a John Doe. So there's some workarounds for that. And also, maybe you have to come up with a process or a policy of how to continue to serve them without entering them into data systems where they could be identified. They must be informed of their housing protections and occupancy rights at the beginning. When you first meet them, and you're giving them that stack of paperwork, you've got to give them the VAWA spiel. You got to say, this is your rights, right? You're a VAWA. If you are a VAWA household, here are your rights. Anytime you deny their admission or assistance, anytime they receive notification of an eviction, or if they are being terminated from assistance at those intervals. Regarding the lease bifurcation, this allows the victim and the family to remain in their household while removing the perpetrator from the lease. A bifurcation can be used to evict, remove, terminate the occupancy rights, or terminate the assistance to the perpetrator of the violence. It is not a perfect tool, right? Somebody said earlier, what do we do? Who's the victim? Who's the abuser? What if the head of household is the abuser? What do I do? It's complicated. And so this is a disclaimer, right? It is not that easy. And sometimes you don't even know who the abuser is. I've had a case where I'm like, they're both abusing each other. So, you know, it gets complicated. It allows a perpetrator who are otherwise eligible to have 90 days to establish eligibility into their current housing program, or to establish eligibility in another housing program, or to find alternative housing. So you could be housing both separately. And so again, it is complicated. It can get complicated, and it is not always you know, easy to figure out. But again, document, and ensure that you have the proper procedures and your policy in place to be able to make those decisions. Survivors have a right to report the crimes and to seek emergency assistance without them being penalized. Okay, so the provisions that protect people's rights, including their tenants, landlords, residents, guests, occupants, homeowners, and applicants for housing, they have a right to call the police and seek emergency assistance from their home without any type of penalization or threaten or being threatened for exercising their rights. Where it's like, okay, you've had 5 calls to the police. They've been over here, you know, 5 different times because you guys keep having these incidents. You're going to lose your housing, right? They have a right to be free from that, to call the police and exercise those rights as needed to protect themselves or their family. Emergency transfer plan. An emergency transfer plan has to be developed when a tenant requests a transfer, when the tenant believes they are in danger or imminent harm of their unit, or when they've been sexually assaulted in the unit within the last 90 days. The housing authority or housing provider can ask for documentation, unless documentation has already been provided, but this documentation can, again, be a self-certification. And the tenant gets to define what a safe unit is, not us as the practitioners. They get to tell us if they feel safe moving to this unit. Okay, so we don't get to make that decision. The tenants do have a choice. And again, it's complicated. We only have so much housing. We may not even have housing available. We have to try to figure this out. What are we going to do? At the end of the day, the tenant gets to define if they feel safe moving to that unit. Transfers can be internal, that is to a safe unit that's immediately available through the current project. If a safe unit is not immediately available, the tenant can request an internal transfer or an external transfer. So it could be, for example, you transfer them to another public housing authority who does have space available. If a safe unit isn't immediately available, for an external transfer, the survivor must complete an eligibility and application process for the new program. The PHA cannot retaliate against people who have exercised their rights under VAWA or have testified or assisted or supported people in exercising their rights. Policies and procedures should be scrutinized for the necessary changes concerning VAWA households, and they should reflect pre-existing VAWA provisions, including the updated provisions in the 2022 reauthorization. So you're going to take what you have and you're going to build on it. Okay, you're not going to redact it because those laws are still in place and they're still good policies and procedures. You're just going to add to those policies and procedures. And additionally, you're going to make sure all your staff are trained and know and understand those policies and procedures. And at minimum, they must be in place that govern the identification of the VAWA household, confidentiality, and the notification of rights. They must provide for lease bifurcations, emergency transfers, and prohibit retaliation and coercion, and allow VAWA households to seek law enforcement without penalty. So these pieces right here are the crux of what you're going to add to your policies and procedures. Can we ever evict a household, right? So tenants can't be evicted, denied admission, assistance, or terminated from participation on the basis as a direct result that they've been a victim of domestic violence. But what if they're not paying rent? What do we do? What if they're not paying rent? Do we just evict them? They didn't pay their rent, or they have a scattered site voucher. They didn't pay their portion of rent, right? Can we just evict them? Failure to pay rent could be linked to economic abuse. The abuser could be preventing the person from getting or keeping a job. They could be preventing the victim from access to money that could have been used to pay rent. The perpetrator could be using the victim's resources or otherwise prevent rent from being paid. So this is where those discussions with the household, the VAWA survivor, need to take place. What is happening with your money? How come you're not able to pay rent? Sometimes it's just not crystal clear, right? Sometimes you may need to get a third-party payer involved, where there's an organization that's going to help you pay this month because for whatever reason you couldn't come up with your rent. I think this is the piece where a lot of folks get terminated because they're not paying, right? And the landlord says, hey, you didn't pay. Well, we're going to give you a 3-day notice to comply. And the next step is an eviction. This is where, again, you have to document, and try to work with that household to determine what is going on. Are they experiencing some sort of economic abuse? Can you reduce their rent? Can you give them the minimum rent? Right? If the breadwinner is the abuser and they were the one that was bringing the money home and they are no longer bringing the money home, and this is a VAWA situation, what options do you have as an organization to help get them through this situation so that they can not lose their housing or be terminated due to economic abuse? Can poor credit history negatively affect a household's eligibility for your program? Yes. When can it be linked to domestic violence? Sometimes you may see economic abuse, such as bad credit, where an abuser has forced a victim to get credit cards, ran them up, or maybe forced them and kept them from getting a job, putting debt in the victim's name, or forcing the victim to turn over money to the perpetrator. Sometimes maybe they're payee on their Social Security benefits, right? But they're not using that money to pay bills. So often you'll see something in their credit history, which could be grounds that you would normally say, hey, you're not eligible because you're not meeting certain qualifications. In this case, is it linked to domestic violence? Can a poor rental history negatively affect their eligibility? Yes. Perpetrator behavior often causes property damage, noise complaints, police calls, harassment, criminal activity, and early lease terminations or evictions. So sometimes you'll see in their history where they have a poor rental history. The landlord before couldn't wait to get them out because they were just a huge problem. And those are things that are common when we're talking about domestic violence victims, particularly when they're trying to escape their abusers. They may have a poor rental history. Could they have a criminal record? Yes, we talked about this earlier. Sometimes a perpetrator can force a victim to write bad checks, misuse credit. They could have a lien or be lying on a tax return. There's often things that would result in poor credit history and a criminal record. So perpetrators can force a victim to sell drugs. They can force them to sell sex, and sometimes that ends up in their criminal record. And perpetrators can force victims to steal, threaten, and harass other people. There's a whole variety of circumstances that could show up in a criminal record that could be related to the Violence Against Women Act. And lastly, we are at that time. We are right at 11, right where I wanted to stop. You guys did great. This is where we're going to pause and take some questions. There will be a link in the PowerPoint to all the resources that are listed in this presentation. There are resources under HUD that I think are extremely important when we talk about VAWA. And I'll just mention on our way to getting to questions is that HUD is enforcing VAWA. It is been enforced in 11 different cases, actually 12. The 12th one just showed up as of last week. Over the last, I would say 6 or 7 months, where HUD is doing conciliation agreements with entities that have violated VAWA. I have seen cases that have been where HUD makes you pay a fine, attorney's fees, settlement agreements. I have also seen where HUD ensures that you update all your policies and procedures and kind of monitors that through continuous quality improvement. So throughout the country, at this point, there's about 12 cases that HUD has enforced under VAWA, under FHEO. And so it is happening. So I hope today was helpful so that you guys now understand the law and that you can do your due diligence to protect your organizations and your staff, and more importantly, to protect the people that could be experiencing violence within your housing programs. And I'm going to move to the final slide, and I see Elizabeth coming off of mute.
I just had a question regarding the HUD and them kind of enforcing this. Are they getting involved when there's a report of a violation, or are they being proactive in going out and kind of doing audits and assessing people's programs that they have in place?
That's a great question. So I have only seen, just from my experience, and I actually had a chance at a fair housing conference to meet with some of the HUD lawyers that are enforcing the VAWA cases. And I think at this point, from what I've seen, and I'm not positive, so I don't want to speak for HUD, I have seen that complaints have been made, and HUD has decided that they fall under VAWA and FHEO and has picked up those cases. As of March, HUD enumerated those 6 steps that organizations have to take and said that they will be enforcing. I do think, though, HUD has spent a lot of time over this last year doing VAWA outreach. And so I think when a federal law is passed, sometimes it takes a minute for folks to get ramped up and be trained and to know and understand the law. But will HUD be enforcing? Yes, they are enforcing now.
Right.
And if I were an organization and responsible for a housing program, I would make sure that I was in compliance with the law as much as possible. To prevent folks from, filing, right? Because we're already doing everything in place with our policies and procedures, but also B, to ensure that we're doing our continuous quality improvement so that when HUD does come and they do show up, that we are in compliance. Thank you, Elizabeth, for that. And I'm going to open it up for folks to come off of mute. We have a few more minutes if folks want to just say anything. Your feedback is always welcome.
Dr. Hill, Sheila has had her hand up for a while, so I'm going to allow her to talk. Sheila, go ahead and take yourself off mute.
Thank you. I had a couple of questions. I wanted to go back to the concern about the difficulties. And what I'm learning is the difficulty is when we have clients that are involved with situations where we have to wait for them to attend a briefing, to be issued a voucher. Are we allowed to find some type of temporary housing for them until their unit passes inspection and all the things that HUD require us to do in a transfer situation? Because I'm finding just within the past month or so, I have quite a few clients that are doing VAWA, that are under VAWA situations, but we can't move them because we have to wait for them to get a voucher. We have to wait for them to locate a unit that they want to go to. We have to wait for the unit to be inspected before they could physically move in. And during this time, anything can happen to that person, and it's nothing that we can do. So when you say an emergency move, what does that look like? Because it's looking like our VAWA people are waiting just like our normal request to move folk. And I'm not sure if it's putting any of our clients in harm's way to make their situation worse than what it already is. And yes, the abuser does come back 95% of the time. The abuser does come back. So when does HUD tell us, okay, you have allowed this abuser to come back? It takes money and time to keep moving them every time they open that door up. So it's a twofold question. How do we move them in an urgent matter without having to go through the inspection process or what have you, just until that unit can be inspected? And B, when do we say, okay, you continue to bring this abuser to your unit, and every 6 months we're moving you because you keep bringing this abuser? What kind of authority do we have to kind of put a stop to the continuing moving? Because every time we move you, every 6 months, you're being moved because you're bringing that person back.
So first, I'd like to address your first question about can we get around our inspection procedures, right, to move somebody in quicker? And that's a great question. I haven't had that before. And honestly, I don't know the answer. But that would be a great question that I would ask HUD, right? I would ask HUD, I would probably do an AAQ to HUD under VAWA and say, hey, do we have the ability to, go around HUD's policies and procedures around a person is supposed to move in when the inspection is completed and passed, right?
Right.
I know Inspire also has a lot of new rules about when a person can move in and, kind of getting around some of the last sticking points where, until everything is done, you can't move in. Now there's some leniency there. So I would be interested to see what HUD would say about that. I think that's a great question. However, on the flip side, while I'm waiting, I would, if I were in charge of that housing program, I would do whatever I would need to do possible to ensure that inspection happened as quickly as possible, right? So I would try to percolate that person to the top of my inspection list to get that inspection done quicker, just because there is a sense of urgency. And then if it didn't pass, I would work with the landlord to try to get it to pass and then get that property re-inspected as quickly as possible. So that would be my thoughts around question one. Question two, with allowing the perpetrator to come back. This is that gray area and there is no perfect answer. And you said 6 months. I'm like, that's a long time. I've seen people next week, I moved and they already just let him in. They helped him move in. So there's that, right, where the perpetrator is attempting to reunite with the family. And so, or the person who's the survivor. So I think there's that balance that we talked about earlier around document, help the household with support, right? Get the domestic violence advocates involved, and do everything that you can to protect that person, and ensure that you are creating a whole kind of, list of all the things that you've done around that person still coming back to that unit or attempting to reunify with that family. It's going to be really important, particularly if something happens in the future that is not desirable. But again, these are gray areas. It's very complicated and there is no kind of just, oh, we're just going to fix it. I have seen people move folks several times because they find them again, or they've let them know where they're staying at, or the children told him, or the neighbor told him we moved over to this, especially in small towns, where there's only so many housing projects or what have you, and you couldn't get that person away far enough. So there's multiple circumstances that can happen. Again, documenting, doing everything you can to support the family, ensuring that you have the domestic violence advocates involved, and continuing to ensure that everything that's within your power, right? Sometimes we feel powerless, but everything that's in your power is being done.
Great, George, go ahead and take yourself off mute if you have a question.
Thank you. Yes, I had, well, two questions. Going back to if you can't hold the head of household accountable if they're a victim of violence, but what if both adults in the household are arrested for domestic because it's unclear who the primary aggressor was?
Yes. So that was back to that slide around the bifurcation of lease. And let me try to get you back over there to it. So this is the complicated part, right? Who's the victim? And how do we bifurcate the lease? This is where we talked about it is complicated, right? There sometimes isn't a clear roadmap to, okay, what exactly needs to be done here? And I think this goes back to how do we amenably do this to protect both people, right? If they're both abusers or perpetrators. So this bifurcation under federal law allows perpetrators who are otherwise eligible to have 90 days to establish eligibility in their current housing program. So you may have to give them their own housing voucher, or to establish eligibility in another covered housing program, or to find alternative housing. And I know that's probably not the answer that you wanted to hear, but this is what's prescribed under federal law.
No, thank you. My second question is and this just came up the other day, we have an individual who's on our housing choice voucher wait list. They've claimed VAWA and stated that they should be moved to the top of the wait list. So I guess, does the claim of VAWA allow somebody to improve their position on a waiting list?
So here again, this is where it gets complicated. I would need you to tell me, does their claim of VAWA allow them to move to the top? What policies and procedures do you have in place when somebody claims that they're experiencing domestic violence, right? Do you have a threat assessment in place? What are the, circumstances? Is the person in imminent danger, right? And these are things that are complicated to try to define and decide, but this would go back to your policies and procedures that you have in place. Or do you think this person is just kind of gaming the system? What if you're wrong? Okay, and this is the side of caution and liability that I always err on. What if we are wrong? What if this person really is in imminent danger? What would we do then? And so in my mind, I would want to do what we need to do to protect the survivor. And that would be move them to the top of the list if that's what your policies and procedures define.
Thank you.
You're welcome.
Dr. Hill, we have a question from Kurt. They're asking, can a resident request a lease bifurcation to remove the perpetrator when no lease violation has been issued?
Yes. You would need them to self-identify, right? Fill out that certification form. If they tell you that it's happening, again, believe them. Sometimes it takes a while for people to come forward. It is a very often scary situation. Fear can do a lot of things. So if somebody comes forward and they tell you that there's a problem and they need to get this person out of the house because of domestic violence, you need to believe them.
We have another question from Richard, and I imagine this is a case-by-case basis and depends on the details, but is a break-in considered stalking?
Is the break-in from an intimate partner or somebody who would qualify as under the domestic violence laws? Or is this a perfect stranger? So let me go back to our list of who is protected, right? So when we talk about who's protected, this is folks who have experienced domestic violence. So is this person who broke in somebody who had a relationship? Let me just get this back up for you. It's a PowerPoint. I'm sorry, I can't see where I'm at anymore. Let me stop share and start again. So can I hear a little bit more about the person who broke in? Do we have information about the person who attempted the break-in?
We don't.
Okay. I'm not sure if you guys can see that. So let me try to get it going.
That question came in from Richard Marshall.
Okay, can you guys see that? Might need to swap it.
Yeah, we don't have anything on the screen right now.
Okay, you can see that. And if you can see my notes, great. It just makes you even smarter. But we have, so the term domestic violence, is this a current or former spouse or intimate partner of the victim or person similarly situated to the spouse of a victim? Is it somebody who has cohabitated with them or some sort of intimate partner? Do they share a common child in common? Or that has committed acts against the youth or victim who is protected under family or domestic violence laws of the jurisdiction? So then the question would be, who done it? I hope that's helpful. If it is a former, intimate partner, etc., then they're covered under VAWA. If it is not, I probably would still be looking at the safety of that unit because landlords do have a responsibility to provide some sort of safety, of a unit.
I had
So
a
this
question around that safety piece. Can someone under VAWA request additional safety measures in their unit? So like putting in a security camera or adding additional locks or bars on the windows. I didn't really see any kind of mention of that in the act, but I didn't know if you've seen anybody do that.
That's interesting. I actually really like that question, and I'd be interested to hear if any of our housing providers have done any of those measures. I don't know if that's a requirement under the law that you must provide these ancillary things, but I do know there are some protections that landlords are supposed to provide some sort of safety around a unit, that if there's like a crime going on all the time and police reports are being filed, that the landlord, people can in their tenancy early, they can do things of that nature to get out because they don't want to live there anymore, break their lease because there's been crime. So I do know there are some protections from that regard, but as far as a housing provider providing bars on a window, security cameras, things of that nature, that's not prescribed under the law, and I don't know if any housing providers have actually done that. So I'd be interested to see if anybody here on the call has actually done that, and then we will take that as the last question because we are out of time. I can't see all the answers on my side, just so you know, but I'm just wondering if anybody has actually.
No, we haven't gotten any, but we have a ton of questions. And what we can do for the folks who have open questions is we can document all these and run them by Dr. Hill. And in our follow-up email tomorrow, we can attempt to answer them if there is an answer. But if it's something that's a little more specific and situational, we'd urge you to contact Dr. Hill directly and work through that situation. But we appreciate
Yeah, I just dropped my email in the chat. I'll make my disclaimer now. I probably can't answer every single question, but I can do my best to help you problem solve. I will offer that because it's important to me. And I think this is the work that needs to be done because this is the real work, right? These are real life situations. This is a real life approach. We're talking about human lives. So if I can help you problem solve and make your organization stronger and make you stronger as a worker, I'm here to do that. That's what I do. That's what I've been doing for the past 30 years. I don't even know what else I would do. And when I retire, I'll probably still come back and volunteer. So I want to say thank you guys for showing up today. I really appreciate you. I want to say thank you so much to the HAI group for having me. This has been an awesome partnership. And I hope you learned something, folks that attended. I hope you learned a little something. And we will be sharing the PowerPoint. And I look forward to hearing from you all with your questions.